If you are a business operating in a developed market, you would have a reasonable expectation that the judicial system would enforce your lawful rights in a timely manner. What does the enforcement of rights or resolution of commercial and regulatory disputes in India really look like in practice? Or rather in numbers, it takes over 1,445 days, nearly 4 years, to enforce a contract in the city of Mumbai, our financial capital. Over 55 million cases are pending across all courts in India. It would take 324 years just to clear the present backlog. Why is the Indian judiciary plagued by these delays? The answer, as with most things in India, is nuanced. Hello and welcome back to the Veyrah Law series. If you are a business operating in a developed market, you would have a reasonable expectation that the judicial system would enforce your lawful rights in a timely manner. While the same principle also applies in India, the challenge lies in the timely enforcement of these legal rights. In this video, we will try to understand the challenges that one would face in India for enforcing rights and why that requires a fundamental rethinking of the way businesses structure their affairs in India. My name is Ajay Joseph, and I'm a partner at Veyrah Law. We're a law firm based in Mumbai, India. To know more about us, you can take a look at our website. The link is in the description below. Before we get started, a quick reminder. These videos are not advertisements or solicitations. They are only for sharing information. Nothing shared here should be treated as legal advice. Please consult your own advisors before making any decisions. Lastly, please read the disclaimers carefully. With that out of the way, let's get right into today's topic. If you are not familiar with the Indian judicial system, let's first understand how the Indian judiciary is structured and which parts matter to a business operating in India. To start with, the Indian judicial system is divided into criminal courts and civil courts, all operating under the supervision of a high court. There are also specialized courts and tribunals for criminal and civil issues. Civil courts at the district level typically serve as entry points for lower-value business disputes in India. These courts handle a range of matters like non-payment claims, service defaults, or recovery proceedings. That said, most high-value commercial disputes no longer begin here, especially after the introduction of the Commercial Courts Act in 2015. This led to a reallocation of commercial litigation to specialized courts within the existing framework. District courts, as the name suggests, have jurisdiction in a particular geographical area for all commercial matters in that area. There are, of course, other courts within the hierarchy, but they deal with matters of much smaller monetary value and may not be of relevance to most businesses. In each state or union territory, the highest judicial authority is the High Court. Any decision from a district court within the state could reach the High Court by way of appeal. Sometimes one or more states and union territories may be under a single High Court. For instance, the Punjab and Haryana High Court, based in Chandigarh, has jurisdiction over all matters in the states of Punjab and Haryana and the Union Territory of Chandigarh. A few High Courts also have jurisdiction to hear commercial matters at the first instance, depending on the monetary value involved. For example, the Delhi High Court or the Bombay High Court. At the top of the hierarchy sits the Supreme Court of India. The Supreme Court, as the name suggests, is the highest judicial authority in India, and all courts and government authorities are bound to follow the law laid down by the Supreme Court of India. Matters lie in appeal to the Supreme Court from the High Courts and some appellate tribunals. The Supreme Court also has jurisdiction to hear matters in the first instance, like disputes between states or states and the central government. In this discussion, it would also be relevant to speak about the tribunals in India. In the last few decades, the Indian government has also set up specialized tribunals that are meant to operate outside the procedural rigors of the traditional court system. Some of these tribunals deal with matters of significant importance to the business community. The National Company Law Tribunal and the National Company Law Appellate Tribunal deal with shareholder disputes, insolvency matters, and corporate mergers under company law. The Income Tax Appellate Tribunal deals with direct tax-related appeals. The Securities Appellate Tribunal deals with appeals from SEBI decisions on securities law issues, and more recently, appeals from the Insurance Regulator of India, IRDAI. Add to this dynamic the adjudication powers at first-level regulatory authorities like SEBI, IRDAI, Income Tax Department. A business in India can very quickly get overwhelmed in litigation management. While the specialized tribunals and regulators were empowered to provide a speedy resolution of disputes, the results have been far from satisfactory. Let's take a close look at some data points. What does the enforcement of rights or resolution of commercial and regulatory disputes in India really look like in practice, or rather in numbers? We will limit our discussion to the courts and related enforcement systems that would matter most to anyone doing business in India. According to the World Bank's final Ease of Doing Business Rankings 2020, India ranked 163rd globally in enforcing contracts. On average, it takes over 1,445 days, nearly 4 years, to enforce a contract in the city of Mumbai, our financial capital. That's just the average in a large metro city. In reality, complex commercial or regulatory disputes can drag on for much longer. This is not an exception. It's the rule. Let us compare this with OECD country averages. The United States ranks 17, taking 370 days to enforce a contract. The United Kingdom ranks 34, taking 437 days to enforce a contract. France ranks 16, taking 447 days to enforce a contract, and Germany ranking 13, taking 499 days to enforce a contract. Let's look at some Asian counterparts for perspective. China ranks 5, taking 485 days to enforce a contract. Even Vietnam ranks 68, taking only 400 days to enforce a contract. To put things in perspective, here are some approximate figures from the National Judicial Data Grid Government of India figures as of December 2025. Over 55 million cases are pending across all courts in India. Out of this, around 90,000 cases are pending before the Supreme Court. 78% of those are civil matters. In the Supreme Court, more than 15% of all cases are between 5 to 10 years old, and almost 10% are over 10 years old. Over 6 million cases are pending before the various high courts. Around 69% of those pending are civil matters. In the high courts, 22% of all cases are between 5 to 10 years old. Another 22% are over 10 years old. As per public sources, cases in some high courts date as far back as 1951. Still unresolved, 74 years later. But the bulk of the pending cases are all before the district courts, approximately 47 million cases. Strangely, in the district courts, around 80% of the pending cases are criminal cases. 17% are between 5 to 10 years old, while 9% have been pending for more than a decade. Our tribunals fare no better. Tribunals in India have a backlog of approximately 520,000 cases as of November 2025. As per the National Company Law Tribunal's March 2025 case status report, 14,961 cases remain pending before various benches. In the Securities Appellate Tribunal, 1,170 cases were awaiting resolution as of May 2025. Almost 98% of the pending cases are appeals from SEBI's orders. Among the appeals challenging SEBI's orders, 5 appeals filed in 2018 are still pending. 138 appeals across all case categories filed between 2018 and 2022 remain pending. According to the report of the Standing Committee on Finance on demands for grants, up until September 2024, around 23,903 appeals were pending with the Income Tax Appellate Tribunal, and the amounts locked in dispute was a staggering rupees 6.85 lakh crore, which is approximately 75.5 billion US dollars. Similarly, there is vast pendency before important regulatory authorities, such as SEBI, RBI, and the Income Tax Department, which includes delays in commencing cases where the issue at hand could be many years old. And that's just part of the backlog. The official government-run think tank Niti Aayog, in one of their publications, mentioned a study carried out by the Ministry of Finance, which suggested that it would take 324 years just to clear the present backlog at the current rate of disposal. Now, some of you may be wondering how the mechanism of arbitration fares compared to the court system, especially given that most modern-day business agreements contain provisions for resolving disputes through arbitration. While arbitration proceedings do actually operate faster than trials before courts or tribunals in India, the challenge really lies in the enforcement of the arbitral award, be it from a domestic tribunal or from an international arbitral tribunal. The arbitral award against an Indian-based counterpart would generally have to be enforced within the Indian judicial system. No surprises in assuming that the system just adds the arbitral award into the existing backlog. As of December 2025, approximately 1.1 million proceedings for enforcement of final court orders are pending across courts in India. These proceedings are for enforcing orders of courts obtained by litigants after first battling their case for 4 to 5 years. A case in point is of a successful foreign litigant who was armed with a favorable arbitral award against an Indian counterpart from a reputed international arbitral institution. They are stuck in Indian courts since 2016 to recover the monetary claim awarded to them. This state of affairs can be summed up by paraphrasing an observation by a Supreme Court bench in a recent case. Litigation does not end with a decision, as execution of a decree is an entirely new phase in the long life of a civil litigation. Clearly, these issues and timelines are not random. They stem from deep-rooted structural issues within the system. So why is the Indian judiciary plagued by these delays? India's judicial backlog is the result of several interconnected factors: structural, administrative, and procedural. This has also been highlighted by the international media. The fault for this unfortunate scenario cannot be squarely placed at the doors of any one government institution, but is a collective issue. Let's look at some of the main reasons that lead to such an unfortunate scenario. First, to begin with, there simply are not enough judges. In India, as of 2025, the judge-to-population ratio stands at 15 judges per million people, well below the 1987 Law Commission recommendation of 50 judges per million population. Compare that with other jurisdictions. The United States has around 150 judges per million. Europe averages around 220 judges per million. And the problem isn't just numbers. Many judicial positions remain vacant due to inconsistent recruitment. In December 2025, the actual number of sitting judges across the Supreme Court and all high courts stood at around 858, but well below the sanctioned strength of 1,156 judges. That's approximately 25% vacancies in the constitutional courts of India. The district courts and specialized tribunals do not fare any better and suffer from the same issues. The district courts in 2025 had 20,478 judges against the sanctioned strength of 25,771 judges, and at least 18% of posts for members of many of the tribunals are vacant. 93 positions remain empty against a sanctioned strength of 518 members. Even assuming all vacancies are filled, the judges to population per million would still reach just 19 judges per million, way below the recommended benchmark of 50 judges per million. On a related note, as per public sources, it is frequently reported that the government is the largest litigant, with the state or union government as a party to nearly 50% of all pending cases, making it India's largest litigant. Even the Supreme Court in the recent past observed that at least 40% of litigation by the center or state governments is frivolous. Another point to note is that the state enjoys procedural advantages, such as a 2-month mandatory notice period before suits, extended periods of limitation. That is, the rights of the state to protect its interest in a dispute does not lapse for an extended period compared to private litigants. Regulatory proceedings can be initiated by government bodies for past non-compliances without any limit on look-back periods in most cases. But beyond the numbers, there are also procedural and behavioral patterns that contribute to these delays. The absence of an effective costs and penalty regime. This issue has been the subject of discussion in Supreme Court judgments, Law Commission reports, and even discussions on the floor of the Parliament. While some amendments have been introduced in the law, and courts have been given the power to award costs to a successful litigant, they rarely ever exercise this power. This means litigants can file weak or frivolous cases with little downside, often as a tactical tool to delay or pressure the opponent. Secondly, there is a low threshold for admitting claims. Many courts routinely admit cases relying largely on the arguments of counsel, rather than based on the substance of the claim through documents. As a result, even unsubstantiated or speculative claims can enter the judicial system. Often cases are admitted for trial, even where the position in law is fairly well established by past precedent. The next on the list is perjury and false pleadings are seldom penalized. This lack of deterrence allows parties to misuse process and drag out proceedings indefinitely. Lastly, even if one were to obtain a successful outcome in their favor after a long trial, followed by, in most cases, another long appellate process, the final outcome would need to be enforced through a separate execution proceeding. This is especially relevant in commercial disputes where the successful judgment holder from an arbitral award or other commercial proceedings has to necessarily file another proceeding to implement the outcome. For example, recovery of money owed, restoration of property, and the likes. As mentioned earlier, as of December 2025, approximately 1.1 million proceedings for execution are pending across courts in India. All of this contributes to a system where litigation can easily become a strategy rather than a solution. And in this conversation, we're not even getting into the criminal justice system, which is another major concern for enforcement of rights in India. But it is relevant in some contexts for businesses when it comes to directors' criminal liability or financial fraud. But the criminal justice system suffers from a combination of judicial delays and an inefficient investigation system, which takes years to complete an investigation, especially for corporate frauds or financial crime. The Union government, in a recent discussion in the Parliament, submitted that the Enforcement Directorate, the premier agency investigating money laundering offences in India, had secured 120 convictions from 6,312 cases it filed in the 11 years from 2014 to 2025. Further, according to the periodic reports from the National Legal Services Authority, under-trial prisoners make up approximately 74% of the total prison population, reflecting the slow pace of judicial processes in serious criminal matters. These statistics are a telling story of the challenges of getting involved in any manner within the criminal justice system in India. So what do these statistics mean for investors and businesses operating in India? If enforcing rights can be delayed significantly, businesses operating in India need to internalize some basic risk management principles. A well-drafted contract with the best legal positions may not be the most useful tool for risk management if enforcement of that contract could take years. This is a significant departure from developed markets, where businesses often rely largely on contracts for risk management. Litigation risk should be a key part of commercial strategy. Businesses need to factor this in, especially in joint ventures or partnerships, where relationships can sour quickly and unexpectedly, as we have seen in multiple cases. It does not take long for best friends to turn into arch enemies. In India, litigation isn't about winning. It's often about leverage, or rather, to redefine what winning means. Local businesses understand this. Possession and interim reliefs are strategic tools. For example, in a contract dispute, one party may seek an interim injunction to freeze assets or restrain the other side from certain actions, not to win the case, but to pressure the other side into settlement. It is no surprise that a well-known saying exists. In the Indian context, possession is not just 9/10 of the law. It is often the law itself until the case ends. But if enforcing a contract and securing rights through the court system can take years in India, one must really ask the question, are the best drafted or negotiated contracts the ideal solution in an Indian context? The answer, as with most things in India, is nuanced. Let's see what investors and businesses in India could do, keeping the delayed enforcement scenario in mind. While this is not an exhaustive list, here are the top 10 points we would suggest to manage potential dispute risks in India. On the top of the list, diligence and more diligence. The old adage, prevention is better than cure, does not hold more true than in an Indian context. There are many great business partners in India, but there are also many unscrupulous players in the market who would promise the sun and the moon. Always diligence your partners, the assets, and the business you plan to work with. There are professional advisors who would assist with such exercises in India. The past conduct of a potential partner is a good indicator of how they will behave in future. Structure through an intermediary entity. It does not matter if the intent is to set up a partnership or operate through an own entity. If you plan to have a legal presence in India, use an intermediary holding company outside India to channel investments. This isn't about tax arbitrage. Instead, the purpose here is risk insulation, ensuring that disputes or regulatory issues in India affect only the Indian business and not the foreign parent. Indian law recognizes the principle of limited liability, but it is not difficult to drag a foreign company through Indian courts in frivolous litigation. Insulate the parent company from such potential risk by investments to an intermediary entity. Ensure that the intermediary has a functional board, maintains separate books, bank accounts, and records, and takes formal approvals for all material decisions, including investments and contracts. Avoid complicated structures. If the business is dependent on approvals from a regulator to commence business, like insurance, banking, financial services, avoid using complicated structures which regulators may need more time to understand. Once the license or approval is obtained, the business can explore creative structures. Courts are usually considerate to protect an ongoing business from regulatory overaction. Focus on practical contractual risk management. When dealing with business partners in India, avoid getting caught in endless negotiations over indemnities and other theoretical clauses. Instead, think commercially. Structure payments, performance securities, and milestones so that risk is managed in real terms. For example, in joint ventures, commit capital based on milestones. In supply arrangements, take payments in advance. Retain portion of payments for performance-based contracts. Do not rely solely on contracts. The most elegantly drafted airtight contract will still take years to provide you the final remedy in the Indian justice system. Prioritize good faith and clarity. Many disputes arise not from malice, but from misunderstanding. Encourage partners to record commercial terms clearly in term sheets or MOUs. Keep legal drafting simple. Contracts are meant to record commercial agreements, not obscure it with unnecessary legalese. Depending on whether you are selling or buying, learn to use objectivity and subjectivity in contractual clauses to your advantage. For example, if someone has to obtain a remedy against you, subjective provisions are to your advantage. If you need to obtain a remedy against someone, objective provisions are to your advantage. Remember, in India, the one who needs to initiate a litigation is already at a disadvantage. Focus on operational checks and balances. Ensure appropriate governance mechanisms are in place to monitor business ventures with partners. Avoid positions of directorship on boards of joint venture Indian companies if possible. An observer status will achieve all the commercial requirements with none of the legal risks. Structure protections through contracts and charter documents of the joint venture company. Keep an insight on banking transactions through online monitoring on an independent CFO. Don't threaten litigation, prepare for it. In India, open threats often escalate matters. A better approach is to document your positions without threatening legal action. Avoid introducing lawyers to the other side into a developing dispute discussion. Business teams often document and concede many positions over business to business communications. When anticipating a dispute, have legal teams review all communications and develop your fact position based on the ongoing exchange with other sides. Introducing lawyers too early will cause all parties to become cautious. Always keep legal teams at the background unless things have come to pass and a litigation is inevitable. Understand interim relief thoroughly and its merits in India. Obtaining interim relief depends on certain basic principles. Ensure at all times that the facts in a situation are managed or created to allow presenting before a judge that not obtaining an immediate relief would cause irreparable harm. Do not look to obtain justice in commercial matters. It's more practical to almost always explore a settlement. As we mentioned earlier, leverage and possession are everything in the Indian context. The one who goes to court to seek relief is the one with the weaker position. Always ensure that you can retain leverage and only approach courts to arrive at a settlement. If dragged into litigation, look to settle on your terms. Depending on the other side, court proceedings can be a useful way to bring people to a settlement discussion. Learn to absorb losses and move on. Prolonged litigation will only lead to monetary costs, time cost, and lost opportunity in pursuing other meaningful business opportunities. Last but certainly not the least, avoid letting egos drive litigation strategy. We cannot emphasize enough the importance of being pragmatic and practical in possible dispute scenarios. Potential disputes in India require a cold, hard look at the reality of the situation. It is not personal. It is not about emotions. Commercial litigation needs to be about just numbers, measured in terms of time cost and real benefits of indulging in prolonged litigation. Litigation is time-consuming and costly. We have seen one too many litigants launch into battle despite several warnings, only to demonstrate remorse and fatigue as the litigation drags on endlessly in Indian courts. Understand your worst position and always be open to settle if a better position is playing out. This is not a one-size-fits-all rule, but should be the general principle. Always keep channels of communication open with the other side on respectful terms and assert your positions respectfully. Indian businesses are largely promoter-driven and by consequence are driven by strong personalities. Keep communications assertive but respectful. While these are some principles to keep in mind, there is no one-size-fits-all for India. It will always depend on the facts and commercial realities at play. But one thing is for sure, the delays in enforcement are real and should be accounted as a material risk for doing business in India. To summarize, judicial backlog is real, but careful structuring and foresight can minimize exposure. Enforcement is slow. Settlement in a commercial dispute will almost always be the best strategy. Business disputes are often about leverage, not the law. Avoid getting caught in ego disputes. Learn to settle disputes, cut losses, and move on. We cannot emphasize this point enough. The number of unwanted disputes that get created because two sides could not communicate with each other on reasonable terms, allowing egos and personality clashes to create easily avoidable litigations. As the saying goes, in India, the process itself often becomes the punishment. The wise businessman plans not for victory in court, but for avoiding court altogether. We hope this episode gave you a realistic picture of how enforcement works or may not work in India, and how to plan your business affairs accordingly. As always, if you found this discussion useful or know someone who would find this information useful, please do share it. And if you have questions on anything related to this topic, drop them in the comments. Someone from the team will surely respond. Thank you for watching and see you in the next episode.